In our very first story, Cape Coast High Court has restrained the MP-elect for Assin North, James Quayson, from holding himself out her search. A Mason and a resident of Assin Breku, Michael Ankoma Inimfa, had filed the case at the Cape Coast High Court for an interlocutory injunction over the dual citizenship of the MP-elect. Richard Chonyako was in court and has filed the following report.
The interlocutory injunction was sought by Michael Ankoma Inimfa, a Mason and a resident of Assin Breku in the Assin North constituency of the Central Region. He prayed the court to restrain the MP-elect of Assin North from holding himself as such. On Monday, an ex-parte application that was sought by the applicant was transitioned into a motion on notice where both the applicant and the respondent argued out their cases. The case of the applicant was that James Quayson, the MP-elect for Assin North, did not qualify at the time of filing his nomination to contest the 2020 elections with the Electoral Commission and thus did not satisfy the requirement under Article 94 of the 1992 Constitution and the provisions set out in the CI 127. He prayed the court to restrain the MP-elect from holding himself as the MP-elect and also restrain him from being sworn in. Lawyers for the applicant further argued that at the time the Electoral Commission closed nomination on the 9th of October, the MP-elect had not renounced his Canadian citizenship and only got the renunciation certificate on the 26th of November 2020, weeks after he filed to contest. Lawyers for the MP-elect challenged the capacity of the applicant, but the court intimated the applicant had sufficient capacity and dismissed the challenge. They also asked that the case be stayed by the High Court and the matter referred to the Supreme Court because it bordered on the interpretation of Article 94 of the 1992 Constitution. Lawyer for the MP-elect Abraham Amaliba argued in court that the article that set out the requirement of an MP was ambiguous and ought to be referred to the Supreme Court for interpretation. They were clear in their minds that once the application for the renunciation of the Canadian citizenship by the MP-elect was set in motion, the rest were administrative duties that were not within the control of Mr. James Quayson, the MP-elect, and should not be punished based on that. Justice Kwesi Boakye in his ruling indicated Article 94 of the 1992 Constitution was clear and unambiguous and did not warrant a referral to the Apex Court. He also thrashed out the challenge over the capacity of the applicant. The High Court judge proceeded citing various authorities by the court on the said article and based on such authorities granted the wishes of the applicants through an interlocutory injunction, but added the matters raised in the petition by the applicant were so grave that the matter would require a full trial. Gary Nimakun is a lawyer for the applicant.
Basically, the application put before the court for injunction to restrain the Assin North MP has been granted on account of the fact that the foundation of his qualification to Parliament is under serious challenge. We are saying simply that, look, at the time that he filed the processes before Electoral Commission, he wasn't qualified to have been allowed to file in the first place because at the time when he did that, he was holding on to his Canadian citizenship. And it's not clear. They were in court, they didn't challenge the fact that he was given certificate of renunciation on 26th of November 2020, which is post-date the time of filing, post-date the time of elections. So clearly, I don't think there's an issue. The court has done the right thing. We cannot put something on nothing. The foundation is very weak. You want to go to Parliament, you must be only a citizen of Ghana. Dual citizens are not allowed to go into Parliament. And therefore, the court has held so that the injunction application is square-lies and that you cannot go to Parliament. That is the fact of the matter.
Where do we go from here?
The case will take its normal course, which simply means that we'll come back here to continue with the case to determine the fullness of the case.
So we are just coming from the court. The judge also intimated that the full-scale trial ought to be done. So you see from this place people that are clad in red. They disagree with the courts, with the outcome of the decision that has been taken by the courts. We do not know their leanings, but obviously they are not really happy with what the decision has been.
The challenge is Breku no fi. On person Breku be yankoso. That adia oyane. This guy annoying from 2000. 2005. And it is out to Chrome, or your mamma for Second Basabasabi, and see what's in offer. And you are coming in front of my based on the judge report. Based on the judge report.
Obviously, these are residents from Assin Breku, where the applicant comes from, and they are not happy that the applicant has brought on this decision that is restraining the MP-elect James Quayson, who comes from the same town with them. They are not in the least happy, and they are warning that they don't want to see him there because he's brought some embarrassment to that community. He is someone who does not want development of the place, and so that is the warning and the notice these residents who traveled all the way from Assin North are serving the general public. From the Cape Coast High Court, my name is Richard Kwejonya for Joynews.
Lawyer for the NDC MP-elect for Assin North, Iram Amaleba, is meanwhile unhappy. His attempt to file a stay of execution regarding the Cape Coast High Court ruling was unsuccessful under very interesting circumstances. He's been speaking with Gifty and Apia.
We also took a strategy. The strategy was that even before the judge starts reading his ruling, we would go to the registry and file a notice of appeal together with a stay of execution. So my colleague lawyer, who was with me, Edu Yaboa, immediately the judge entered, he also got up and went to the registry. So I even introduced my colleague in absentia. So for the period that the judge was reading, and I think it took like 45 minutes to read his ruling, for that whole 45 minutes, Edu Yaboa was at the registry. After he finished delivering his ruling, I followed up to the registry, only for Edu Yaboa to tell me that they haven't found the filing clerk and that she has locked the office and they are looking for her. Whilst I was with him there, a call was placed by the registrar to find out where she was, and that she was at Solpong. She had left her office and gone to Solpong. So we kept hoping that she will return, or they can open the place and then assist us in filing our stay of execution. But whilst we were there, physically to, file our processes, the registrar and the judge had drawn up the order, that's the injunction order, and sent it to Accra through electronic means. And they also left the premises.
Minority Leader Haruna Idrisu has been reacting to the ruling by the Cape Coast High Court, describing it as a selective application of the law in the country. He was speaking on the floor as the House, the seventh Parliament brought proceedings to a close.
Voted for 137. Mr. Speaker, I pray and I look forward to a Ghana which does not have different set of laws and rules for NDC MPP, but the rule of law in all its facets, including equality of law, is upheld and respected at all times. Different ruling in Techima to have representation, different ruling in Assin North not to have representation, that can only be a manifestation of some legal illiteracy.